Oh yes, this is something you would represent. That color.
I think there were 60 people registered, so
All the teams filled up.
except for like one or two spots on like a couple teams, yeah. But for the most part, it's filled.
That's what I just said. Let's ask.
Hello.
I mean, you're doing freedom. Oh,
Ana.
Ay, mucho gusto. ¿Qué tal? Adriana.
Sorry,
No te había conocido.
sorry. Exacto, no, por eso.
¿Qué tal? ¿Cómo estás?
It's great. No one from my team was doing it.
Tranqui, tranqui. Se me va cayendo el brazo. Julia.
Está la tarea, tía.
No idea.
Necesitaba.
Okay. Let me close these doors and then we'll.
No, I mean.
Thanks to like the two groups that joined in person. Good to see you guys.
Yeah, we appreciate
All right. Welcome everybody. I'm assuming you all can hear me. If not, please make yourself heard. If you don't know who I am, I'm Dan Chilton, president of the European Law Student Association at IE Law School, and also the director of the Mitchell L. McLean mock trial competition. We're very, very pleased to have Tim Lendino here with us today, who is the Assistant General Counsel of Compass Group North America, which is, I believe, the largest food service company in North America and also the world. So big company, about 250,000 employees, and a big legal department. So Tim, I'll let you introduce yourself and talk a little bit about your background, and we'll go from there.
Okay, sounds good. Everybody hear me okay? Okay, cool. Yeah, as Dane said, my name's Tim Lendino. I work at Compass Group now. I have been a lawyer now for, I guess, about a little over 12 years. So just sort of some background on myself. I went to school here in the States. I went to my undergrad at, we call it undergraduate here, at UNC Chapel Hill, and then I went to law school at a small law school in North Carolina called Campbell. After law school, I did a judicial clerkship with the North Carolina Business Court, which, if you're familiar with like business litigation in the United States, you may have heard of something called the Delaware Chancery Court. That's like a court in Delaware that hears only business disputes. I essentially worked for that same court in North Carolina in the United States. I did that clerkship for a year, which is a trial court that does complex business cases. And then after that clerkship, I went and worked for a large law firm that has over 500 lawyers or so that did commercial litigation, basically the same thing that I did when I was a clerk. I worked in that law firm for 7 or 8 years, just as an associate, just grinding, billing hours, doing all sorts of things, including mediation. But most of the cases that I worked on were in federal court here in the United States. So all over the place, but mostly kind of regionally in the Southeast. And then also in like some of the state courts, the business courts that are here in the United States as well. Had kids, and my wife works. She's also a lawyer. We both couldn't do it, so I decided someone needed to change. She had a much higher earning potential and career path than I did at the time. And so I decided to pivot my career and go in-house. And I've been at Compass Group now for a little over 4 years. And now I still am involved in litigation, but at a much more sort of like tangential way. I'm not as closely involved in sort of the day-to-day cases, the things that happen in the cases that we have going on. I'm much more sort of at a distance, kind of commenting on strategy at a high level. And most of my day-to-day job now is transactional in nature. It's just sort of corporate, commercial contracting, which I probably enjoy a bit better than litigation, just because it's feels more productive in the moment. Sometimes litigation can feel, like both sides are just yelling at each other and spending a lot of money, and what's sort of the end result. You can get really cynical in litigation. So, and you have to be sort of a tough personality, and I'm more of a peacemaker and a deal maker than I am a fighter, sort of in my personal nature. So got out of the litigation game a few years ago, but still get to sort of still remain involved. That's sort of my high level sort of overview in 5 minutes about what my background and how I am here today. So I'll stop there. And Dane, I don't know if I can just dive right into what I was going to talk about, or if we want to just open the floor. This is kind of, here's my little agenda thing.
Yeah, I think, well, first of all, what's your question policy? Do you want people to ask throughout, or do you want them to save it to the end? How do you want that to work?
I'm here to talk about whatever anybody wants to talk about. So if someone has a question at any moment in time they want to ask me, just go for it, and I'll do that. And otherwise, I'll just kind of tick through sort of my prepared remarks, but there's nothing I'm really going to say that's really that enlightening. So I'm much more interested in answering questions that folks may have.
Great. Yeah. So we have a lot of people here representing mock trial teams, but then we also have some people just part of the association who are interested in hearing what you have to say. But I mean, you all heard him. If you have any questions throughout the process, throughout this thing, raise your hand, or signal it online, or we'll take them at the end as well. So great. Yeah. Go for it.
Okay. Yeah, just interrupt me if you ever want to chime in. I definitely don't want to just talk, but here's sort of an agenda, like some things I was going to talk about is just sort of what's the role of an in-house lawyer in commercial litigation. I got the impression that that's not something that really has been discussed in the mock trial or the classes so far. Is that fair?
Pretty fair.
Okay. And then I'll talk about sort of mediation, how we see it sort of from a corporate perspective, go through some sort of mediation strategies. I'll kind of be using my prior experience to sort of talk through some of that, because there's all sorts of different things you can do strategically, and I'm happy to answer questions. Like there's a lot of strategies, and I'm sure there'll be a lot of questions on like, what should you share? What should you not share? There's always this tension on how being truthful, like being candid with the opposing counsel or with the mediator, but then also I don't know what the right word is, like withholding information, right? You're always sort of keeping your cards close to your vest, and how do you sort of navigate through some of that? So I'll get into some of that. And then, I looked at the cases really briefly that everyone is working on, but I only sort of looked at the briefs. And so I have a very high level understanding of what your cases are about. But if you get into like, hey, what is so-and-so's deposition summary or affidavit say? Like, I have no idea. So I won't be too helpful there. But anyways, yeah, so let me get going here. Sort of what's the role of in-house counsel when it comes to commercial litigation? I would say there's a couple different functions. Really, it's like assessing and mitigating whatever risk you have, whatever the litigation matter that has come up, like quickly assessing that and trying to mitigate it is one thing. But it's really like managing two different things. You have as an in-house lawyer, your main clients are the business teams that you support. So it might be the executive team of your company, the CFO, the CEO, those folks, and you're really trying to navigate for them, like, what is our risk here? What's our exposure? And then managing their expectations. Most business folks have a very sort of basic understanding of like how the court systems work and what litigation is involved. They might not even know what litigation is, like really, really basic things. And so a lot of your job as an in-house lawyer is literally explain to them the basics, like the things that you learn in your 1L, your first year of law school. You're explaining that to someone who doesn't know the court system or doesn't know how things work, doesn't know how much money the litigation costs. That's like probably the biggest thing, is a lot of times business folks are like, oh, well, we just want to fight this. Commercial litigation is expensive. Like if you do a full-blown commercial litigation matter, depending on the amount of controversy, like the cases that I worked on, for example, the amount in controversy might be $5 to $10 million. Say that, just use that as an example. The demand is $5 million. Well, if we were going to like take that case and defend that case at the law firm all the way through a trial in a business court in the United States, we would spend over $1 million likely in legal costs, law firm cost in taking that case all the way through trial. Most business people have no idea like the cost of litigation. And so explaining that to business folks is like a really key role of in-house counsel. So managing the expectations of your business folks on litigation is important. And then also sort of managing the outside counsel. And those are the law firms that you hire here, so like we have outside counsel that we hire to go and, defend us and represent us in court. So I don't actually go myself to court. The outside law firms are going and working for us in court. But as the in-house lawyer, it's your job to sort of make sure that they're doing all the right things, right? So they're running all the filings, all the pleadings, all the discovery, anything that they're doing in that case, they're going to be running by the in-house lawyers to make sure it's approved and make sure that everything's good to go. And then you're making sure that they know the goals of the litigation. And usually, before you even really get that far into a case, you're going to figure out, like, what are my objectives here? Is it to settle at this point in time? Or is it, if I'm the plaintiff, I'd have no desire to settle. I want to take this all the way to trial and to prove a point or for whatever reason. So when you're working with your outside counsel, you're really serving as a liaison between the outside lawyers, who are the ones who are in the courtroom doing the work, and then all the business people that are your business clients. As the in-house lawyer, you're sort of in the middle there, because the outside lawyers, they're so in the weeds on the litigation that they are not really great at speaking directly to the non-lawyer business people that they need to talk to. And so the in-house lawyer is really serving as that liaison between the two and sort of channeling or funneling the needs of the litigation, which can be complex, down into like a layman's way for the business people to understand, oh, okay, like this is what they're asking. So the in-house lawyer will be responsible for taking all the discovery requests that have come in or figuring out. That's a great example, like, funneling the discovery requests that come in and then going and helping and finding the responsive information, finding the right witnesses, finding the right people that will serve as your deponents. I don't know if y'all have gotten into like corporate depositions yet. The Rule 30b-6 deposition, is that ringing a bell? Okay, never mind. Doing the in-house lawyers really serving as that liaison. And then I would say the most important thing that an in-house lawyer does in litigation is like learn from it and then enact business changes that will prevent problems from re-happening. And so that's a big thing that I do now, is like when we find things, a lot of the things my company is not very litigious. So we hardly ever let a dispute get to the point where a lawsuit is filed. We will almost always try to find a business solution, a resolution of that case, and usually it involves just paying money to make it go away. But when we do find problems that happen in our business, we try to fix we try to find the root cause of that issue and then fix it. So it may be some dispute over the wording in our contract that is not very clear. It's ambiguous. We will, okay, well, we got to fix that. So we'll make a change to our contract templates that we use for all of our contracts, and so that that verbiage is no longer, in our contracts. Or, oh man, we found out that the way we do business, the way we bill a vendor, a client was somehow wrong or fraudulent. Okay, well, let's develop a new policy or procedure about our billing to make sure that certain information is disclosed or whatever. That's a really key function of in-house lawyers. And so those are sort of the key roles I would see in litigation. I'll pause right here for a minute before I move on. Any questions based on what I just said?
Yeah, and if you are going to ask a question, introduce yourself and also say where you're from and maybe what case you're doing if you do have questions. I'm not sure if we might start getting questions around the strategy area, but we'll see.
Okay.
No?
All right. So more specifically about mediation from a corporate perspective, I will say that from my view, mediation is certainly the preferred way for dispute resolution. And it's what most in-house lawyers want to do, and they want to have a successful mediation because the in-house folks from the business standpoint are looking at the risk of the case, and then they're also looking at costs, like I mentioned before, like the legal cost of defending or prosecuting an action. And successfully mediating the case handles both of those things. It stops the legal spend and it finds a resolution. It removes uncertainty from the business. And so it's certainly preferred. It's so preferred that in our contracts here in the United States, a lot of people, when they have a commercial contract, will put in a clause that there's a couple different clauses we have in the US. So we'll have, perhaps a form selection clause that says if there is a dispute, it has to be resolved in a certain form, or it'll say, we call it an arbitration clause. So a clause that says you have to resolve that dispute in arbitration. And so most forums will have mediation as a requirement in it, right? So if you ever litigate a dispute in the federal courts in the United States, by the rules, you have to mediate, right? It forces you to go through mediation during the pendency of that lawsuit. In addition to that, contractually, we have clauses where we will put in certain contracts that before you can even file a lawsuit, you have to mediate. The parties have to mediate the dispute before they file the lawsuit. And we do that because we don't want to have litigation. Now that presents an interesting situation because then you end up having to go and mediate a dispute before you've done anything, right? You only have sort of he said, she said, the parties' allegations against each other without having done any discovery, without having really put your allegations perhaps in a detailed writing, like in pleadings. And so mediating in that situation before you've done a lot of work in preparing a case can sometimes be honestly counterproductive or not productive at all. And so that's one of my big points here is really being a good lawyer is about figuring out when is the right time to try to mediate and try to find a resolution in your particular case. And that's really going to change case by case. So if there is, for example, a dispute where the facts are like highly disputed and both sides really feel strongly in their view that they are correct, then having a mediation before you've done like discovery on facts is probably not going to be productive, right? Because the sides are going to say, oh, well, this is what I think it is. And the other side's going to say, well, I disagree with you. And if you haven't done discovery and gotten to the bottom of, or at least tried to sort of figure out what the facts really are, then you're never going to find common ground. And so in some cases, like in litigation here in the United States, like there'll be like a case management conference, usually early on in the case, between all the parties and the judge usually. And in those settings, the judge and everybody will say, when do we think is the best time? When do we think will be most productive in having a mediation? And the parties will say, well, we think we actually, like in this case, we really don't have a big factual dispute. We just have this like legal question that we need resolved before we can mediate. Or the parties may say, oh, well, we have all this discovery we really need to do before we can really feel like we know the facts of the case. And until we know that, we really can't mediate. And so depending on those circumstances, the parties will select when the right time is to mediate. And so a lot of times people will mediate later in the case, like right before trial, after you've pretty much done all the discovery and you feel like you know the facts. And at that point in time, it's like, okay, well, let's just try to solve this because nobody wants to roll the dice in a jury trial or a trial before a judge. Or the parties may decide, you know what, we don't want to spend all this money in the litigation, like on our lawyers, all of our legal costs. So it'd really be more advantageous for us if we settle earlier, because we'll have more money to potentially pay, right? It's really hard to settle sometimes later in the money if a party has spent all of their budget on legal costs. And so those are the sort of considerations. I would say the most like important consideration from a corporate standpoint, from an in-house lawyer, is determining when is the best time to mediate. And then sort of what is the role of an in-house lawyer at a mediation? And I would say the number one role for me is preparing, again, my business clients on like what to expect and how the mediation is actually going to go. So just honestly telling them like, here are the fundamentals of how the mediation is going to proceed. Here's what I think is going to happen. Here's, you know, here are the sort of the likely scenarios that are going to play out, and then going from there. What you don't want to have happen is for your business client to show up and be surprised by anything that happens at a mediation. So that's probably one of the most important roles. All right. So then I have sort of a slide on mediation strategies. And I'll stop really quick before, are there any sort of questions before I just kind of walk through some strategies?
Okay, interesting. Yeah, just an FYI for everybody, like this is something that you can pose in the context of your own cases. And I'm sure Tim can also answer questions about generally pursuing litigation in a United States court, which I think would also be an area of questions that may happen. So just keep that in mind. Raise your hand if you have any. But like I said, I think after we talk strategies, we might have some more questions.
Okay. So here in the States, when you do a mediation, before the mediation, you will prepare a mediation statement that you would share with both the mediator that you select and then usually the opposing party. And sometimes you can do that there's a couple different strategies that kind of go into your mediation statement and in what you want to share with the mediator before the mediation even begins. And so some people will want to put in their mediation statement here is sort of my case. These are my best legal arguments or my best factual arguments. They want to make it more argumentative. And then they'll go into even saying, this is what my opening demand is, or this is what, these are the kinds of things that would be included in a settlement or some type of a resolution. They'll even put like a framework of what, kind of the deal terms that they might be open to. I never did that. And it was most of the time people didn't want to put their cards out in writing before the mediation, but separately sometimes, so we would have a mediation statement, for example, that would go to the other side and then also to the mediator. And then we would call the mediator separately, confidentially, and talk to the mediator before the mediation about, here's where I think this case might be able to settle at, or I want you to know this about this case, like sort of some separate side channel discussions with the mediator to sort of give the mediator additional context, maybe help sort of get the mediator to be a little bit more on your side. Who knows? But that's sort of one strategy, or one sort of decision point is thinking about, okay, well, what do I want to say before the mediation? What do I want to, how much detail do I want to put in the mediation statement? Sometimes people, if the mediation is towards the latter part of the case, I've seen situations where on the eve of the mediation, say a summary judgment is about to happen in the case. On the eve of mediation, one side would serve the other side with their summary judgment motion and their brief that supports the summary judgment argument. It was a way for them to sort of assert additional leverage and to scare the other side with, hey, if we don't settle this at the mediation, these are the legal arguments that I have that I'm going to, be presenting to the court to basically make this case go away and prevail. So that is usually, that's a pretty powerful strategy that I saw deployed pretty well. The one that I did the most work on was, we had sort of a case where it was similar to that, where the mediation statement, we had found a bunch of kind of like a smoking gun in discovery, and we hadn't told the other side about it yet, that we had a really a bad email from the other side where it had a bad concession in it. Hadn't confronted the other side with it. We gave that email with sort of our view of like how it impacted the case, like the legal argument for it. We gave that to the other side the night before the mediation. So there's little tactics like that that you can do sort of right before the mediation to sort of scare the other side, or to sort of try to assert some pressure, so that when you show up to the mediation, maybe you've influenced them a little bit to want to make more concessions than they might otherwise have wanted to. Opening statements in a mediation, is that something that this group is going to do? Like, are you going to go through actual mediation where you're going to do opening statements?
Yeah, so there will be, time for each side to state their case at the beginning, like uninterrupted, but then it just becomes an open mediation.
Okay, yeah. I would say the opening statement is probably, it's such an important time strategically in the case. Perhaps one of the most important times in terms of, and think about it this way. It is like one of the only times that you as a lawyer are going to be able to talk directly to the other party. Not the other party's lawyers, but directly to the other party themselves, right? The actual principal parties in the case. It's like one of the few times. And so because of that, it's a really powerful moment because up until that time, in most instances, everything in the case has been filtered through the lawyers. So that party is only getting, it only knows about what's going on in the case based on what its own lawyer is telling them. So it's your rare opportunity to talk directly to that person and be like, this is what this case is about. And these are the facts that we have. These are the arguments that we have. It's a very powerful moment where, and I would say that's the most important thing in the opening statement, is to focus it on what do I really want to tell that opposing party, not their lawyers. I'm not talking to the lawyers in the mediation opening statements. I'm talking directly to that party, and what message do I want to get across to them? How will my statement be most effective in swaying them one way or another on however I want to sway them? So for that reason, I oftentimes, I'm trying to put myself in the shoes of what that opposing party, what who they are, right? If it's a lawyer, if it's a sophisticated business person, they might be more understanding of legal arguments, and so I can frame my opening statement to be a little bit more legal argument-y. If it's just a lay person that doesn't have that much business acumen, then maybe I have to make it more focused, less legal argument and more sort of just fact-driven and in that way. And so that would be like my big sort of strategy point on the opening statements, is really try to tailor them more to speaking to the opposing party, because you can't otherwise talk to that person. And the only other times that you would talk to the other person in that case is when you take their deposition and then at trial. So those mediation, deposition, trial is like the only opportunities where you're actually engaging directly with the opposing party as opposed to through their lawyer. For an in-house lawyer, it's important to try to obtain or think about obtaining some type of settlement authority before the mediation and at the mediation, and thinking creatively about a mediation. At the end of the day,
oh yeah, Tim, they all have settlement authority when they go to mediation. So that
okay, everybody has that. Okay. But what is the settlement authority? Do you have is it just dollars, or are we talking about you have different?
It's fully encompassed, everything from dollar amounts to resolutions involving payment structures and community service agreements, and I mean every case has a different ask, obviously, but everybody has essentially full business authority to act on behalf of whatever entity they're representing.
Right. I gotcha. So yeah, it's in that regard, it's important to think about in commercial litigation here in the States, at least, dollar is everything, right? Everything can be distilled down to just money. And that's ultimately the easiest way to settle a case is just with money. It's much more challenging to settle cases where there are certain sort of performance obligations or certain things that need to be done. So oftentimes, and that's what makes it very challenging, because a lot of times what people want is not money. It's something else. It's an apology, or it's some type of future action that you want the other side to do, or the other side wants you to do. And so weaving those into the settlement or the resolution is pretty challenging, but it can be done. And so I'll give you one example. The law firm that I used to work at primarily representing large corporations and usually defending cases and then sometimes prosecuting them. But in a few situations, we would represent the plaintiffs in just miscellaneous cases. And in one case, we represented this plaintiff's family that had suffered a tragedy where they were staying in a hotel that had a carbon monoxide poisoning in it, where a young boy and the mother passed away, and from carbon monoxide poisoning in the hotel. That family felt as though, in the hotel, I should say, did not have carbon monoxide detectors in the room. And a carbon monoxide detector is like $10. It's very cheap. It's just something that the hotel industry could do. That family, what they wanted in a mediation wasn't a big cash settlement. What they wanted was a commitment by that hotel that they would put carbon monoxide detectors in all their hotel rooms. It was a national hotel brand. So they had hotels around the entire United States. And the hotel didn't want to do it. Now, the hotel was suffering from such reputational damage from that case that they ultimately, as a condition of that settlement, said, we're going to go and we're going to put carbon monoxide detectors in every hotel in the country. It was going to cost them, a couple $1 million or something, which was not that, in the family's mind, was not that expensive, but the hotel didn't want to do it. But that was a rare situation where the family was like, I don't care as much about the money, but I want them to do something. And brokering those types of settlements are probably some of the more challenging situations. But that's a cool example of one that actually worked.
Yeah, and every case that we have has some element of non-financial ask from one side or the other. So
okay,
think-
that's interesting. That makes it hard because, how do you value those? It's really hard to negotiate those.
a lot of it is admission of guilt, right? I know a lot of companies just don't want to admit that they did something wrong.
Yeah, I don't know if I ever saw I don't think I ever settled a case where there was an actual apology or an admission of guilt.
Actually, I think we have a question.
Yeah.
Yeah.
You want to introduce yourself? And
Yes. Hi, I'm Anna. I'm from Argentina. We're doing the pharmaceutical case.
Yeah.
I was wondering, how do you reconcile, for example, if you are representing a client who cares a lot about reputation, and you don't want to go to trial necessarily, and you want to settle, but the other party is asking for, this apology is very important to the other party. Have you been in a situation where you've had to manage that? And how?
Yes. Yeah. Honestly, in that situation, it just increases the settlement value of the case, because the companies are probably never going to give the apology or the admission. And so how much money are they willing to pay then to just eventually get that person to say, okay, I'll take the money and I'll forego the admission of guilt or the apology. And I can say that it can be tenfold, a factor, an insane factor, to try to make things go away. We have a case, we have a certain issue in our business where we've paid multiples of what the demand or what the value of the case is, just to make the issue go away, because we didn't want the noise of the issue to create a bigger issue and to get out, basically, in the industry. So we've had a case where you'll find this one really entertaining, actually. So we had a case where we lost at the trial court, and I'll just use fake numbers here, but say we lost at the trial court and it was $10 million that we had to pay. And we said we wanted to appeal, or the other side wanted to appeal because they thought that they really could have gotten $20 million. And we said, we will pay you the $20 million right now to make you not appeal and go away. And they were like, no, we're going to appeal because this is important for us and we want to send a message. And we were like, okay, then what if we paid you 25 million, right? We're paying you more than what you could ever get in court, just to make it go away, because we don't want the press, we don't want the precedential value of an appellate decision, of a decision out of the Court of Appeals, because we know that from a media standpoint, that will get spread across our industry and will be worse for us because other, people out there will hear about it more and then, perhaps raise similar issues. So that's an example, real world, where we offer more than what they could ever get in court and they still say no. Because, I'm just trying to prove a point or whatever. And so those are really challenging. I don't have a great answer to the question other than, when you have somebody asking for an admission, an apology or admission that you're not willing to give it, then as the corporate party, you just have to pay exponentially high number to eventually make those kinds of cases go away usually.
I think we have one more question over here, Adriana.
Yes. Hi, Tim. Thank you for your time. My name is Adriana. I'm from El Salvador, and we're representing the financial case. So my question, a little informal, but how do you cancel off paying these amounts of money, like this restitution or this compensation, with an admittance of guilt? Because when you pay money, then it means that you did something or that you're trying to hide something, or as you said, that you're trying to hide it from the press, or just not wanting it to get to the press instead of actually going through all of these processes to kind of like prove that you were innocent. Why do you want to do this? Because it's better for everybody to just finish everything during the mediation phase, of course. But the media does not perceive it this way. The media sees it like, okay, you pay off, so that you're guilty. So how do you kind of like leave it clear that not because you're paying certain amount of money during a mediation equals you being guilty?
Also, Adriana, are you representing the bank or are you representing the plaintiff in this case?
We're the defendants. We're the financial institution.
Yeah, it's a great question. It's probably the hardest one. It's one of the harder issues to manage, because you're absolutely right. Once you pay any amount of money, it's going to be perceived, regardless of how you frame it, as admission of guilt. That's just common sense, right? Like, why would you pay the money if you weren't guilty? Why would you plead guilty? Like the criminal defendants that plead guilty and they're like, oh, well, I just did it because it was the lesser of my potential risk or the cost or the stress of going forward. And that's really how, from a corporate standpoint, you try to frame any settlement payment as, okay, well, I don't believe that I owe the money. I don't believe that I'm at fault. And in fact, in my settlement agreement, in my press release, it will always, in big settlements, one of the conditions of the settlement will be for the parties to jointly craft a press release, and then have confidentiality that ties up the rest of the agreement. So basically you say, we agree that this is what can be said about our settlement. And you craft it very specifically to say, so-and-so is paying this to resolve the claims. Does the party, so-and-so does not admit to any guilt or wrongdoing by this payment. And you try to have your press release as positive, as much of a positive spin for the party that's paying the settlement, and then tie up the other party with sort of confidentiality for anything else, right? So they can't talk about anything else about the settlement. But yeah, at the end of the day, the way you're framing it is, I'm paying the money not because I feel like I did anything wrong, but because I'm trying to resolve the uncertainty that is of a bad result that would be worse, right? The litigation in itself is very burdensome on the corporation. And what I mean by that is, like, when you have active litigation going on, it will eat up a lot of a company's resources in responding to discovery and working that case. Like it can be very, very burdensome. And so there is a cost, there is a value in making it go away that's not tied to the actual like value of the claim itself, right? It's like, gosh, it would be so nice if this case would go away because then we wouldn't have to have 5 employees like working all the time to dig up documents and take all these depositions and all this stuff. And so you can try to spin it that way, like, hey, you know, I'm paying this because it's going to relieve an administrative burden on my company and also remove the uncertainty of what may happen if this were to go to trial. You can try to spin it that way. Those are like the best ways you can spin it. Otherwise, yes, it looks like an admission of guilt because, and it is to some extent. At the end of the day, it is. It's you know, if you felt like you were 100% in the right most of the time, and you wanted to take the risk, and you felt like you're going to win it in court, and you have the money to defend yourself, then you wouldn't settle.
I mean, we would, but right now we're only seeing mediation strategy, so I really can't go to court. I would go to court if I could, but we can't. So that's why I'm, you know, whatever you can tell us and advise for this. Thank you.
Yeah, sometimes I should have said that sometimes the mediation strategy is not actually to settle the case. It's to glean as much as you can from the other side to sort of help you like learn more about their case, sort of get some stuff out of them, understand their main themes or their main sort of their main pain points, so that you may want to settle the case later on the eve of trial or during trial. And you just want to learn as much as you can about like what matters to them most during the mediation, because you know you're not going to settle the mediation for XYZ reason.
Thank you.
Anybody else while we're at this stage online maybe that has a question about their own? Yes, Mama.
Yeah, so I'm Nama, I'm Lebanese, and I'm doing the Qatar Airways versus US case. And I wanted to ask if you can elaborate more on like partial resolutions in a mediation, if you can kind of settle some things while still having the main dispute.
Oh yeah, that's a good question. So in that case, are there multiple, like the only partial settlements that I'm aware of that work are when you may have like different types of claims in the case, like or different issues. So in that case, is there more than one sort of core issue? That was the one that was like a Fourth Amendment issue, right? It's like, okay.
Yeah, so I can help with that. I know that in that specific case, they're not only arguing the search and seizure, but the unlawful deportation aspect. There was an entry ban that was placed on a couple of the people that were deported, and there was also, I think, a third piece. So I think that that's what they're referring to, is maybe dealing with one part of that, so that way they can move on to litigation with the main, you know, constitutional issues maybe.
Yeah, that's a great, yeah. So you can totally partially settle cases, and that's strategically like a really great idea, especially if you want to like get a certain claim out of the case that you feel like is weak for you, or may perhaps a distraction from what you think are your is like your core strength or a stronger argument. And so a lot of times in litigation, like here's a great example, like a common claim in the United States would be like you have breach of contract, and then you have sometimes like additional claims for like we call them business torts, but it would be like fraudulent, like fraud or unfair and deceptive trade practices, those kinds of like really things that sound bad. They're like more nefarious conduct. And so oftentimes in the US, what we'll do is like, okay, like I don't want the case to go to trial with the fraud claims in it, because then that opens the door to evidence and arguments and things that I don't want. And so my strategy really is settle that at mediation. And when I settle it, I'm going to make sure that you get a full sort of release of all that claim. So it's gone, it's dismissed out of the lawsuit, so that at trial, you do what's called a motion in limine, where you get it excluded from, any parts of anything related to that claim is then excluded from evidence. So then at trial, I'm only going to focus on the breach of contract claim, which I feel better about. And I know it's a limited scope, limited universe. It's going to work better for me and my theory. So a partial settlement where you're settling one claim, having that issue dismissed from the case, and then a motion eliminated to exclude that evidence from your trial phase. It's a really good strategy. And so in that case, you want to get rid of the deportation claim. Is that what you want to do? You're thinking about potentially settling that out?
I mean, yeah, it depends on how the mediations go, but
Yeah, totally a good strategy to think about for everybody is like, are there certain parts of my case that I can try to settle partially and have that part removed from my case so that it's no longer going to be something that I have to focus on at trial. And both sides are probably doing that. If you have sort of these issues where there's dual issues or dual claims. Yeah.
Anyone else with questions online or over here? Going once, twice. Okay. Well, we have about 8 minutes left. I do think that would be great if you just cover really quickly, like what you think people should share, like how much you should share, and that should be it. I mean, I don't,
Oh yeah. Okay, so this is really good. I'm glad you said that, Dane. Here's my view on it. From an in-house lawyer, I won't. Sometimes we might not even tell my outside lawyer the full settlement authority that I have, and then go a layer remove. Like, what do I tell the mediator? Say, I'm just going to use hypotheticals. Say that my business has told me you can settle this case for $1 million. I'm probably going to tell my outside lawyer that I can settle the case for something less than $1 million. I mean, I'm going to share a lesser authority. And then when I talk to the mediator, I'm probably not even going to tell the mediator what my number is. Because most mediators, when you say, okay, well, I have $800,000 in authority. That's the most that we would settle this case for today. It's $800,000. The mediator probably is going, okay, I can get you to 900. Or, I could probably push to $1 million. Like, the mediators are always thinking, okay, whatever someone tells me is their number, their max, that's never their max. There's always some layer higher. And so because of that dynamic, I'm very reluctant to always share my max settlement authority with pretty much anybody. And I'm always trying to settle underneath the authority as much as I possibly can. And so there's a lot of games that go on there in terms of how much you share. I mean, technically in mediation, everything's confidential, right? So it can't be used later against you in the case. Is that the rules you guys are operating under?
Yes. Anything that happens in mediation is strictly under mediation. So
yeah, it can't ever be used against you or whatever. Well, that's like true and not true, right? Because like it can't be used, like if you make an admission in mediation, it can't be used against you in trial. But whatever you tell the other side in mediation, they then know it, right? So then they're gonna know sort of, what you think your weaknesses are or what you think your strengths are. So everything that you share is sort of confidential, but not really. I mean, it can be, they're gonna remember it at a future point in time. And the same goes for like when you're sharing your settlement authority or how much you're willing to settle for. Oftentimes, like whatever you say, like if I'm the defendant and I put $1 million on the table at mediation and we don't settle the case, then the other side knows, okay, well, he is going to settle for $1 million. So that's my floor then. And I'm only going up from there. And so you have to be careful about that. Which is why sometimes people will do like, are you think it's gonna go back and forth where people are like sharing dollars to settle the case, or is this?
I mean, it's I think it depends on the case. Like I know the pharmaceutical case has like they're talking in the billions, but then like our university cases are definitely a lot more flexible. So but yeah, dollars are probably the main aspect of the mediations.
Yeah.
And it's probably back and forth.
Okay. So like one of the most popular tools that I see used is like people use like kind of like hypothetical. They call them like hypothetical. We call them brackets in the United States, but it's like say you're at like one side's at throwing around like $1 million. The demand is $1 million, and the defendant starts at $1,000. So you have this big wide gap between you, and you kind of go back and forth in these slow little increments. Say the $1 million person's like, okay, well, I'll come down to 990,000. And then the person at the bottom's like, okay, I'll go to 20,000, right? You're making these like small little increments. One thing that people can do is propose like a hypothetical bracket. It's like, okay, well, if you came up to 500,000, then I think I could get my client to agree to X, right? You propose like a bracket where you try to narrow the gulf between the parties. And so a lot of times people will do that, like a hypothetical, like, hey, well, if you would move your settlement demand or your offer to blank, then I think I could propose blah, blah, right? And then say, could you do that? And it's kind of like feeling out the other side, like, okay, well, like, if they know kind of where I'm going to go, would they be willing to come there? And then you're trying to sniff out where's the middle ground. And if they say yes, then you know, okay, I'm close. We might be close to a middle ground. You're trying to figure out where the other party's middle ground is without firmly putting that offer on the table.
Amazing. Martina.
Hi, so my name is Martina, and I'm representing the financial case in terms of the plaintiff. I'm a little bit sick, by the way. I'm so sorry for my voice.
You're good.
So earlier you said that a powerful strategy in terms of like the mediation statement and the eve of the mediation would be to kind of send your smoking gun, like your best point, the night before to scare them off a little bit. But won't that give them an advantage in terms of knowing what your strongest point in the case is?
That's a good, yeah, you're right. It is a good point. It gives them some time to formulate a response to that. So, perhaps a better strategy, sometimes like when you give it to them, like right in the moment of something, it catches them off guard. So the timing of when you convey that is, interesting. You could do it in the statement, in the mediation, in the actual statement. I've seen people like try to catch the other side, like try to like a gotcha effect, like in the moment. In the example I used it for, it was like, we felt like there was no defense to it. The thing that we had, it was like, we had him dead to rights. So it was like, so that's why in that situation, it was like the night before, boom, here you go. You can process it, but like we got you kind of a thing. But yeah, you're right. I mean, it's a good thing. It's a good call out to go, okay, if I give it to them too soon, does it give them too much time to try to formulate a response? And then if it's not, do you want to give them too much information? Maybe you want to save certain pieces of evidence for trial. If you know you're going to go to trial, which all of you are, otherwise you wouldn't, the mock trial is going to go to trial, right? I mean, it has to. And so in your situations, do you all want to save some of your best pieces of evidence for your cross-examinations at trial? I probably would.
Thank you so much.
Yeah.
Any last questions before we? Yes, Noma.
Yeah, sorry. It's gonna be quick, but I just wanted to ask, in class action lawsuits, which is what we're doing, how likely is it for? Because I think like what I'm kind of used to in class actions, or like what I've heard of, is that most plaintiffs get the same settlement. So how likely is it for like the other side to kind of argue for different settlement offers for different plaintiffs?
Just to clarify, Tim, I think they have a like a like a named plaintiff in the case, but then there's also the class behind the named plaintiff, and obviously the named plaintiff wants probably more than the class does. So, or
Yes.
individually.
Yeah. So the way it works, I'm pretty sure, is the settlement that goes to like the class is for everybody gets the same thing, right? But then a named plaintiff will get like a additional, like a bonus kind of a thing. And that's just for sort of having to go through being the named plaintiff and having to carry, whatever. Honestly, the named plaintiffs, at least in the United States, they're just figureheads. They're not like, they're the people, those class action lawsuits are being run by the lawyers, the law firms. And so, but there is like a bonus fee that gets paid to the named plaintiff, but that is never really, it can be a significant amount, but I've never seen like those be like heavily negotiated. It's just like, oh, you want an extra, $100,000 because you were the named plaintiff. Here you go. I don't know. Does that answer the question? I don't know if I did.
Yeah, I did. Thank you.
Okay. But there's not like, you can't pay different people in the class different amounts. They all have to, I'm pretty sure they all have to get like the same. Otherwise it's not class.
I mean, yeah, we have a group of plaintiffs that are representing like the class action. So I assume it's the same for all of them, where they could get a little bit more than the rest of the class.
Yep. You can
Okay.
have like you could have different classes of perhaps like you could have subclasses of different people. And then, but if you have like 20 people and they all want different amounts, then at some point that's not a class. But yeah.
Great. Well, I think we're about run out of time, but I mean, thank you so much for doing this with us. It was very helpful, I'm sure.
Okay. Yeah. I'm happy to answer questions or anything really. So if you feel free to share my info, Dane, and
Great.
if people have questions or just whatever, feel free to reach out.
Amazing. Well, we really appreciate you coming by, and we'll keep you updated on our
Thank you,
meeting.
Tim.
Okay.
Thank you.
All right. Good luck, everybody.
Thank you.
See ya.
Thank you. Do you want to say something else, or do you want to say something else?
I mean, unless you have questions for me.
Bueno, sí.
Vale.
I have a question.